sorry, Mr. Roux, we had a bit of housekeeping to deal with in relation to the inspection on Monday. It ate up some of your time, for which I apologize. But I'm sure you'll have fine-tuned your cross-examination, won't be pretty.
Chair, can I, for the record, state that Mr. de Rover is unable to be here beyond 1 o'clock? So,
you talk.
Mr. de Rover, the National Commissioner, when she came and gave evidence, testified that the plan had been what she called disrupted. Have you been told by the SAPs when they believe the plan was disrupted?
I'd like to say I'm grateful for the videos that I saw yesterday, because I think they show a comprehensive, if very long, summary, but at least they allow that multi-camera view, and the animations I think are particularly helpful. From what I've understood all along, right from the beginning, and what's illustrated in that video, is that at the moment that Nyala 4 bends and cuts to that corner of the kraal, that I take, as it has been told to me, is the moment that the plan starts to diverge from what was anticipated, because that Nyala was supposed to go straight, and 5 was supposed to make the curve.
Now, I
thought the disruption point was slightly different. They intended to keep the people on the Kopi side of the barrier, on the sort of plain by the Kopi. And after when everyone was in position, Brigadier Karlitz was going to give the warning that we're going to do the dispersing and disarming and arresting. He was going to wait for a while and then repeat it, have it translated into vernacular languages, and then they were going to do that. And of course what happened was that he never got that far, because the strikers either decided to go to Nkaneng or decided to attack the police, whichever version one accepts. That, I thought, was the so-called disruption. Of course, there's then an argument, which we don't worry you about, that the plan was back on track when they got to scene 2, but we won't debate that with you. But the disruption, as I understood the police case to be, and Mr. Semenya will tell me if I'm wrong, the disruption was, instead of being able to proceed with what we call the DDA, as it was planned, they had to deal with what they perceived, so they say, to be an attack by the strikers, and they were trying to defend themselves. That I think, in a nutshell, is their case. Am I right, Mr.
It is so, Chair.
Chair, looking at that, because that has come to light after the fact, but I'd put that, in fact, the first disruption already happens when the deployment of the barbed wire is done consecutively and not simultaneously, as Lieutenant Colonel Scott foresaw at the time. So if you want an earliest indication of when the plan already did not, the action on the ground did not reflect what the plan said, that would, for me, be the earliest manifestation. When I asked specifically, with the exhibits available at the time, where they figured that tangibly things went different, that is at the moment Nyala 4 starts to arc. Is it permitted, Chair, to ask a question about this exhibit, because that would be a useful addition?
I'm sure you can ask a question. I must say, I would have thought the first disruption was actually when they moved in Nyala 6. I seem to remember the evidence was that Colonel Scott wasn't aware of it. I may be wrong on that, but the original plan had Nyala 6 in a position where it was. And it was then moved at about 11 o'clock or 11:20 or thereabouts. So that was really the first disruption, in a sense, in quotation marks. Second one is the one you've mentioned, and the third one is the one which I think the National Commission meant. But you want to ask a question. You want to ask me, or you have more chance of getting an answer out of Ms. LaRue?
No. Well, Chair, I know I need to address you, but I know that the owners of the exhibit are the Human Rights Commission. Now, I think that exhibit would benefit from an effort, and I've checked. I'm sure SABC is willing to come to the party, if I can call it that, on that, because I know that it will cost money to do it. But you can identify the command vehicles in those presentations, and especially the animations. Now, what we saw yesterday shows camera views, but those camera views do not equate lines of sight commanders had. If you would use that same principle of the yellow line arcs, it would at least permit in the animation to show what commanders at that time were looking at. Because you get a camera on someone's right. I remember one sequence where there's a camera here and a Nyala drives through the screen left to right, and we see things behind that Nyala where the camera keeps focusing on. That could have been Brigadier Karlitz's Nyala. But obviously his line of sight is different from the line of sight that we are being presented with. And I think the exhibit would benefit for your understanding, but for everybody's, if for the command vehicles, those lines could be included. And secondly, I think that the exhibit would probably give rise to a number of pointed interrogatories for those operational commanders pursuant to it. And I know that you are under a time bound, but you've used that tool for the experts. I don't know if it can be used, but I see that the exhibit as such could give rise to a number of questions, but I'd be answering second-hand. I'd think that there would be reason with what you have to ask them to comment on that, taking into account the direction of their movement and the arc of sight that they would have at the time that those movements occur.
I say that that point has actually been raised with me by Advocate Hemrod, who suggested that that exercise be done. And I'm afraid the suggestion had stayed with me for the moment, but certainly it's something I take it that the SAPS and the Human Rights Commission can talk about. I hope something can be done along those lines. It shouldn't take too long if the necessary willingness is there. But anyway, that's a matter which we don't have to debate further now. Mr. Schaskison, you were leading forward to your microphone.
I was going to say that if there's difficulty in that respect, because there may be budgetary difficulties, it's something that the party should come to the evidence leaders to discuss, because we might be able to assist.
As if something may happen along those lines. But certainly, I'm sure, do you use the expression daadwerkelijke pogings in Dutch? I'm sure those can be done.
But daadwerkelijke poging in Dutch is a punishable offense.
Not in South Africa.
Because certainly the perspectives and the visibility factor will make a huge difference to us as how we understand it, doesn't it?
Well, look, I think the exhibit is extremely useful for giving an understanding if you offset it against the fact that the commanders didn't have multiple camera views. They did not have replays, freeze frames, multiple frames. So they got one chance at looking at it and trying to get it right. So in that context, it is important that you factor in what could they actually see and which facts could they have appreciated, and then decide whether they were in a position to act on those. And I think that would be very beneficial. And if I take that point of Nyala 4 bending as an indication of SABS diverting now from what it was planning to do, it is also important to note that from that moment till the shooting starts, there is 2 minutes in real time available to them. Now, at that time, you see vehicles moving. They're obviously on their way to their jump-off point where that dispersal action needs to start. So their attention and direction are to get towards that end of the line where they will then come around and start the dispersal proper. Are they actually able to observe what the camera is showing us? And I don't want to qualify that unless we can actually draw in on the exhibit the lines of sight, so that you can say, not only say, look, this happens because the camera caught it, but that you can superimpose on it a line of sight and say, look, just on the basis of the line of sight, that commander was in a position to observe that same fact. And then you'd have a point to question them and get them to speak to that, because you've managed to identify every single vehicle there, and the occupants of every single vehicle are known. So I would think that to be a very useful and worthwhile exercise to conduct.
Bearing in mind that some of those commanders would have been inside Nyalas at the time.
Yeah, but that's, like, I know, and that's why I don't, my opinion is second-hand on this point, but I know that Brigadier Kalitz was in the center of his Nyala, sitting sideways, focused on radio communication and occasionally looking out of the windows. Now, I know you are going to Marikana on Monday. I've already contacted General Annandale and recommended that a Nyala is there. I know you have been inside Nyalas before, that you had a chance, but it might be good to refresh that opportunity. But to play that role then and be told where he was sitting, and for you to have a chance, even plot some of these routes and see what can you actually see when you are there. Because I think they are factors that in the end, when judging decisions, can be critical. And we are talking about a serious matter. So if you want to invoke a commander's responsibility, you must get to a point that you can prove that that commander saw, or if you want, I can use the word knowledge, that that commander had knowledge and failed to act on it. And the exhibit, I think, supremely enables that possibility. So I would think that with that in mind, the exercise of Monday might even gain some significance on that point as well.
And Mr. De Rover, if we're engaged in an exercise of suggestions for Monday, we should then probably also have 328 rounds fired next to that Inyala and see if it's possible to hear them.
Yeah, but the same applies to calls of ceasefire. You know, that is true. I think in all fairness, rounds going off, you can feel that you don't have to test 300 rounds, but multiple rounds going off at the same time, there is a limit to the amount of decibels they generate. So you generate that amount of noise, and you can substitute, once you measure the decibels, you can substitute it with white noise. And you can sit in that Nyala, and you can test at least, and it's a sterile environment because you don't factor in engine noise, people noise, and urban noises around it. But you could make that comparison. Is it audible at all? The other thing you could do is have white noise at the decibel level of gunfire play, and you go and stand away from that source 20 meters and yell ceasefire, and get someone who's next to that source confirm whether they can actually hear you.
Ignorance. I'm probably the only person in the room who doesn't know what you mean. What is white noise?
White noise is a polite term for methods of interrogation the US has used to put prisoners under stress, and it's noise that generates in excess of 120 decibels.
So you damage the eardrums and hope they'll confess?
Well, it's not quite at a damaging level, but I can tell you that it's annoying if you are forced to listen to it for a lengthy period of time.
Get the US Embassy to help us, but I'm sure I'm sure our South African police don't know how to do that, but do they?
No,
but we can make
Chair,
a plan.
It's important, and I know that SABC is in the process of exploring the possibility to purchase a long-range acoustical device. Go into YouTube, Google long-range acoustical device, and you will see one used in action by the American police during a G20 protest. And just I warn you in advance, put the volume of your computer to half and see if you can listen to the sound it produces. And know then that the actual sound is at 140 decibels. It does cause injury, and you will want to get away from that area. The aerial denial systems. The second one that exists is a mobile area denial system that it effectively has a large microwave on the top. And it sends out a radio wave at a particular frequency that only penetrates the skin for 0.5 millimeter. It will give you that sensation all of a sudden that you feel incredibly hot and you don't know why. A hot flush times 100. And you just want to move away. That can be projected at 500 meters distance plus. These systems exist. Now, my contention, I've said that yesterday, it's not in arming up, it's in smarting up. But you can expect your police to differentiate the approaches, but the means that are available on the market are generally marketed under euphemisms of less lethal technologies. All of them, every single one of them, has multiple attested cases that they do produce injury and death. So there is...
What you're suggesting is we get a decibel counter, and then we do something to simulate sound at,
Well,
at the relevant decibel reading.
I know that the contentions about the ceasefire shouts, I think they are important because you'd expect that one command of ceasefire would be enough for that fire to cease. Now,
Mr. De Rover, you accept that there are several ceasefire calls which are indicated by gesture, though?
yeah, but
So
are
if-
people
if we
looking
could-
at those?
If we could now return to my cross-examination. You've observed Annexure V2, which is around the movement of strikers, and you've seen the animation, that is V2A. In your statement, Chair, just for the record, it's F 11A, page 18, paragraph 33. There you refer to the strikers repeatedly approaching the barbed wire line and trying to breach or skirt it. Having seen Annexure V2, the video, and V2A, the animation, which indicates the position of the lead group at all times, do those presentations accord with what you were told by the SAPs about the movement of strikers?
Again, what I was told by SABC, and at the time I wrote that, that's before the 8th of March 2013. I'd been shown Exhibit L that does contain SAP's version of photographs that purport to show that they were approaching the line. If we can hold, and I've heard the reservations yesterday to the videos, I have no beef with that. What I see does not support that. So if it can be held that your presentation is correct, then my statement on that point is incorrect.
Mr. De Rover, turning then to the question of water cannons, you'll accept, of course, that water cannons are an important part of the less than lethal equipment that's available to police in crowd situations. You'll agree with that?
Given that they are one of two means that I would qualify as mostly non-lethal, yes.
And now you've seen the video presentation V3, which deals with the use of water cannon on the 16th of August. Does that presentation change the statements you've made about the use of water cannon at Marikana? Do you wish to revise what you said about water cannon in light of what you've seen in that video?
I think it needs to reflect what is seen in that presentation. But like I said, this is 2 years on. You know so much more. You're referring to a statement that was 1.5 years ago, made in the absence of that particular knowledge. It was made to the best of the information available at that time.
But in your response to the evidence leaders, which was only a few weeks ago, you still recorded that the water cannon had been used to spray the strikers attempting to enter the police line, which we interpret to mean the lead group of strikers. If the presentation is correct and is accepted by the Commission, you'll agree with me that that is incorrect and water cannon was never used against the lead group of strikers.
But you have another problem then, because I referred in that response to a number of statements. Again, I don't make these things up. I base myself on at least then auditable information that people make statements, the crew of that water cannon. So I base myself on that. Clearly, from what you have compiled, if we can trust that, what they say did not happen. Or if it happened, they may actually be referring to another time than they thought they were referring, and they're confused on the timing as to when. But that leaves 4 statements, I think, that at least then warrant an interrogatory on that point, whether people want to revise their opinion. And that I need to revise mine, I would take as a given. If you trust the veracity of what is said there, then of course.
And you'll accept that it could be that those statements, in fact, are referring to the use of the water cannon against other strikers, not the lead group that come around the kraal. You accept that possibility?
Well, again, I'm speculating that people may have been mistaken about the fact and the timeline. So I would suggest that the ones that claimed what I quoted, and I've put the names of the people that made that claim in that reply, that you get them to verify now.
Mr. De Rover will obviously contend that those statements are false in light of the objective evidence that shows how the water cannon was not used on the lead group of strikers. You also in your interrogatory response to Curls, indicated that you had been informed that the water cannon operators were properly trained. Have you been made aware of the statement of Warrant Officer Fourie, Chair, it's H 37, where he sets out what he calls a 2-hour crash course that officers warrant...
Perhaps we could have it on the screen.
We can, Chair. I'm just conscious of time. The phrase they used was 2-hour crash course that warrant officers Kruger and Dix went through. It was not an official course, and they would need to get proper training, but that never took place. If you accept that that evidence is true, all that Kruger and Dix have had is a 2-hour crash course, not an official program, would you revise your opinion that the water cannon operators were properly trained?
The statements I saw from Kruger and Dix do not contain that qualification. So I've obviously seen earlier versions of that.
No, it's a statement by Warrant Officer Fourie,
no,
who describes the 2-hour crash course he gave Kruger and Dix, and that's all the training they've had.
They, in their statements, only referred to the fact that their training was a year ago. And I think in another statement, someone qualifies that they did receive the operator training, but not the training on how to operate the video system.
Right. Warrant Officer Kruger and Dix also acknowledged their training was what they call very limited.
Yeah.
Are you aware of the evidence that Warrant Officers Kruger and Dix were not expecting to have to operate the water cannon, and they did not receive any briefing in advance of the commencement of the operation? Are you aware of that evidence?
It's part of their statements, I think, where they say that it was actually the crew of the other cannon that told them what would be expected of them.
Yes. And you have no evidence to the contrary as to their preparedness to participate in the operation?
No.
So if the evidence is accepted by the Commission that the Johannesburg water cannon operators were not properly trained, first, second, that they were not briefed before the operation other than in a very limited way by the other water cannon crew, and thirdly, that they did not expect to be operating the water cannon in the operation until the very commencement of that operation, if you knew those three things, would you have been concerned about the ability of the water cannon to contribute effectively to the use of less than lethal measures on the 16th of August?
Yeah, of course.
If we can then turn to the utilization of tear gas and stun grenades at Scene 1. You obviously watched the video V4 yesterday, and again I'm going to ask you to assume that the analysis in that presentation is correct. Assume that what is shown in that presentation, namely that the stun grenades and tear gas were only ever discharged behind the front of the lead group of strikers, and that that group consistently moved away from the stun grenades and moved away from the tear gas. So if you accept that as it's shown in the video, then surely you can't say that tear gas and stun grenades were ineffective against that group of strikers because they had the intended effect. The strikers moved away from the tear gas and the stun grenades that were used against them. Would you accept that?
I think it's important to stress that obviously the events as they started to develop there was a 2-minute window until the first gunshots occur. I don't know what at that time the instructions of the operational commanders on the ground are, but they become critical because the fact that Nyala 4 closes at the corner of that crowd causes that group movement to go around. Now, part of the vehicles that I see and understand from what I was told are actually on their way to their jump-off point where they would start the dispersal. I see on that evidence, but I've never, have the detail of who fired, from what direction, the tear gas and the stun grenades. That was first shown, or at least apparent, yesterday in the detail that it was presented. I see that, but they move away from the police. That, I don't know, I think that is open for debate. I do see an acceleration in their movement once they come around that bend and then see the line in front of them. If there was one brief aerial shot where that group is still, I think, seconds before they make their second turn that puts them on an inverse course on the one that they actually were walking on. So in that shot, you see many people actually walking away to the north, and that's the part that, looking at it, I see the two differences and I don't understand it. So, and I just have to leave that for what it is. But I do see that the exercise of trying to isolate the commanders, because I'd like to know, because the use of the tear gas and the stun grenades is still supposed to be subject to someone giving that order. So someone gave that order. It would be important now with this material to try and isolate who did. Especially if you put, your contention is that it causes them to move towards the police line, in fact, or it forces them in that direction. I would still ask why they didn't simply turn around and do what the rest of the crowd did and walk in the opposite direction. So there is a manifest difference in the intended direction of that group and what a lot of other people are doing. But that's what I'm seeing yesterday, and what I'm saying now, I'm saying off the cuff on just watching them.
But let me break this down then. The expected response to the deployment of tear gas or stun grenade is for a protester to move away from the tear gas and the stun grenade, correct? That's the expected response of someone when they have tear gas or stun grenades used near them. It's to move away from those.
Well, it depends on two factors. It depends on a possibility to move away, and it depends on the intention of the use. Specifically with tear gas, you're obviously dependent on wind direction. Because if on that day a stiff breeze had been blowing towards the north, it would have been quite difficult to effectively use tear gas unless you deploy it on the other side. Now, I think, and that's why I put that slide up before, I think that SABC's use of tear gas and stun grenades is more aimed at maintaining that separation between police and protesters. And I see much more, like knowing that, and knowing that preference from speaking to them, that I see the use of that tear gas and those stun grenades there as POP members trying to have that safety barrier between them and the demonstrators. I don't think, because physically it would have been impossible for the strikers to move further away, because that would have only been possible if the kraal hadn't been there. They could have moved towards a westerly direction. So I think that I read the action, and again I'm saying this with respect, that I've only seen that footage yesterday. I'm looking and considering that now. I haven't spoken to anyone about it. I can only read it as an attempt to keep a barrier, to avoid physical contact between the units that are there, actually trying to get to the point where they will move around and start their dispersal, and are then confronted by a number of people that, unlike many others, are coming now around and actually coming towards them.
Mr. de Rover, have you seen any evidence of any barrier being placed between the strikers and the TRT?
No.
If we can then move on to the use of firearms. In your statement, FFF11, Chair, for the record, it's page 18, paragraph 80, you say there that the police were, quote, confronted with a heavily armed group with guns, plural, being fired from within that group. In V5, which we watched yesterday, there's only video footage of one handgun being discharged by a striker. Do you have any evidence of more than one gun being fired within the group of strikers that come around the kraal?
Chair, this is where registered video footage has a serious limitation, because it can only capture what it sees. And
hence my question. Are you aware of any other handguns, any other guns being used by that group?
What I was shown was that in the items that were seized by police after, there were multiple firearms. So, and they obviously also referred to the fact that the group was alleged to have taken firearms on the Monday that belonged to the police, an R5 and a 9mm pistol. So when I compiled, and again, you've had 2 years now, I had 1 week. When I compiled that, I relied on that information to write that particular paragraph. So talking to the people, asking them about what was seized on the scene, seeing that snippet of footage where, okay, there was video registration of one shot, but confronted by police officers who say to me that there were multiple. Whether that was mistake or fact appreciation, where, you know, where your videographer points out that one shot coincides with a stun grenade going off and the sound overlaps. That I don't know. I can't judge that. You have to either isolate officers concerned and ask the question, or ride on the strength of what you know and what you can prove. When I wrote that paragraph, I went as far as I could in auditable evidence in terms of seeing what they seized at that scene and in talking to the people that were there and asking them. And those two combined. And again, like I know your preference is with the first one, that what can be proven, and that you want to accept someone's testimony if it can be underpinned by such auditable evidence, but not necessarily on and of its own. So that is problematic. So my contention would still remain that the possibility that there were other firearms there, I think, is demonstrated by the fact that multiple firearms were seized at that scene. And the police's contention, the way they presented it to me, is that none of those firearms had a full magazine. They had rounds missing. The thing is, I've said that to them, that the fact that rounds are missing doesn't necessarily say anything about when they were used, or whether they were used, or whether someone simply didn't have more than 5 rounds for an 8-round magazine. So these other options also stay open. So on what I've seen and heard, I can't agree 100% with you that there was only one shot fired and there was only one firearm.
Mr. de Rover, have you been instructed that 3 firearms were seized at scene 1, and the only cartridge that was found is a 9mm, which would match the gun that we see fired on the footage? Were you told those 2 facts? 3 firearms seized, only...
Yes, but the problem with the cartridges is that even when I went there on the 26th of March, I kicked up a cartridge in the sand. So I know that the evidence collection at that scene, because of the size, has been problematic. So I know that...
The description of the shot fired there is dissimilar to the one we see on the video.
So, Mr. de Rover, you said that there were 2 sources of information for you from the SABC about the usage of firearms by the strikers. The one was what was seized. We've covered that. You also said you spoke to members that were there.
And there is, of course, the exhibit of
and
the
ballistics. And then the exhibit that
yeah.
Mr. Semenya has just mentioned. Apologies, Chair. I'm just trying to accommodate your conversation with the Commissioner.
Continue to accommodate it. I just said to my colleague, may as well tell you that the police knew that the strikers had firearms and were entitled to factor that in their response. But anyway, firearms obtained in amongst others on the 13th. But yes. I didn't intend to interrupt the flow of your cross-examination by that. But seeing it happened, I've told you what it is.
Mr. de Rover, in any of your interviews with SABC members, did anyone describe in any detail shots being fired from the group? Did anyone explain they saw a striker wearing this at this point, discharging a weapon in this way? Any detail to the contention that shots were fired?
I have a professional problem with the situation that very early on, SABC members have been given warning statements by IPID. So there was a general reticence to be specific with me on detail. There were a few statements that I read of people that said they fired and they thought their life was in danger, and I ventured that if you try to present and convince a third person of imminent threat to life or serious injury, you try to put into words what must be an incredible emotional experience. And having had my life put in danger a few times in law enforcement, I can tell you that I might struggle at times to find the right words, but it's quite a narrative to try and convey that. And the expectation was always put upon us by the court to be as elaborate in describing that as you possibly could, and to try and convey as much of that emotion or fear, because that is in the end what you need to judge, whether such fear existed and whether there was a factor of imminence that warranted and necessitated the response given. Now, I've seen many statements that fall far short from that, and the explanation I was given for that is IPID's involvement, where people are no longer witnesses of truth, that because of their public office can help you and assist you and should assist you to piece together in detail what happened, but now they are suspects. Because these warning statements basically accuse them, tell them you're a suspect of murder now. And you are advised to avail yourself of legal support. You are advised of the fact that you do not have to say anything if you do not wish to do so. Now, personally, I think, well, if I can't really oversee the consequences of speaking with that warning being given, I'd rather say nothing for the time being. And I think many SABC members elected that path, even when I tried to engage them. Let me just tell you that the first session I held with the people for Scene 2 necessitated a general to come in and give them an order to speak to me, because nobody was prepared to answer. Not even a question as to where were you. So I think the problem is that there seem to be competing needs and authorities that exist as a matter of law. There is the international principles that say, as a law enforcement official, you're an agent of the state. You swore an oath. You swore to uphold that. There is a situation to which you can speak. You must speak the truth. You're a witness of truth. And we will treat you as such and hold you to that truth unless we can prove that your actions constitute a criminal offense. Then we'll change tack and tune, and we'll call you a suspect and advise you of your rights that come with that status. Now, what IPID involvement does is actually not consider that aspect of public account and the need for public accountability and the right for the public to know. They step in, they give you that warning statement, and the ball game changes from there. And I think you get constables that have limited knowledge and education and understanding of the consequences and ramifications. They clam up. They don't say anything. And that I think is a lot of the evidence you have is not very helpful or useful to either tell you what happened, when did it happen, who was there, why did it happen in that way, what are the justifications. And under normal circumstances, there would be a delay in involving IPID, because if you put sufficient guarantees in place for the public official role, that in my book would come first, and that you put integrity and professionalism of an organization first rank, you'd first walk that path. And if you're not satisfied that you are getting what you need, you can still change tack. But now, with bringing IPID on there, which is a formal requirement, and IPID not bringing the resources needed to effectively take control, you get a hybrid. You get SABC securing a scene and doing forensics, and you get IPID getting very busy with issuing warning statements to people that were there on the ground. And I think the net effect of it is that it leaves you with a starting point for your quest to establish what now happened, that's most unfortuitous. And one thing I think is that it would probably have assisted the Commission if IPID had been, and I don't know if that's within your might, to tell them to speed up that investigation, to give it priority and to assist the Commission with its findings. Because at least then, if that's now the channel that we are using, that would have produced the information you need, the dockets you need, the information you need to base yourself on, rather than trying to piece it together here, because you're in fact a third line of inquiry now. And that to me is part of the problem that this process is facing, that as an outsider I'm confused, because I hear you when you say it's puzzling that SABC is not conducting its own internal investigation, but if I understand the rules of IPID correctly, they can't. They're not allowed to. It would be considered interference. And IPID has taken this case on board, but hasn't assigned it any priority. It's amidst the tasks that they are performing, and I'm not clued in as to when they actually consider providing their findings to this commission, or more particularly to the officials concerned. And then there is your effort of trying to piece together what now happened. And obviously this commission is formally established, and the evidence that you produce has a formal place. But I think it's also important to recognize that you now at least have three competing processes at stake, that at some stage someone will have to say what is going to take precedence, because I think there is a distinct possibility that your findings contradict IPID, or that you make findings on issues that IPID hasn't considered. And I think there would be a grave interest to at least try and align the processes.
Mr. de Rover, I understand you won't be able to do it now, but if you could refer us to the rule that you just referenced that prevents IPID from doing something. I understand you may not have it to hand now, but you said there was a rule that was going to prevent IPID.
No,
Sorry,
no.
the SABs. Sorry, the SABs.
Yeah.
Taking them up. If you could find that reference in due course.
I will do my best, but as I said, I've taken that on face value. That is just talking to SABC senior officers. They refer to a rule that prohibits them. I've never asked them to qualify that rule, but
well, then we'll take it up with the SABC legal team. Mr. de Rover, given your international legal qualifications as well, you'll agree with me, though, that when an officer waives their right to silence and provides some statement, and if you accept my description of a lot of the warning statements that we have before the Commission, where they admit to killing, they admit to a shooting, but they don't give any of the details of the circumstances that would justify that shooting, that officer is then in a very difficult position, because prima facie they've admitted to potentially killing somebody, yet have not taken the opportunity to set out all of the detail and the circumstances that justify each and every one of the shots that they fire. You'll agree with that proposition?
Well, I think it underscores the problem that we face, because it would be up to IPID then to solicit that detailed statement, and I would expect that to be part of what IPID does. But so they've taken it on record, so they've got a start now. They've got a basic admission of, yes, I fired my weapon, and an answer to the question, did that occasion injury and or death? And that's a start. Initially, you would not require more. In Holland, I know that you get that stage, then you have 48 hours, and then you are, because there's obviously, let's say, your moment-induced confusion and stress and trauma of the incident as such. So you get your initial encounter with central detectives and your warning statement, and then you have your 48 hours to compile your statement, but actually you are then subjected to an interview by our equivalent of IPID, who quiz you on what happened. And what I'm actually trying to stress is, and I've seen that in many other countries, there's actually a close time correlation and requirement between being confronted with the fact that they will treat you as a suspect and the requirement to then follow up. And here I understand that IPID's backlog runs into years. Now, as a matter of international principles, I think that is unacceptable. Because if it's about a theft, I can sort of understand that your priorities are elsewhere. But if it is about the intentional or accidental taking of life or occasioning grievous bodily harm, those are not cases that you can put on the back burner because you have a big workload. And I would think that given that this incident triggered a commission of inquiry, a logical consequence of that would be that an instruction would be given to IPID to give those investigations priority so that it assists the Commission in its findings.
Doesn't your warning before taking a warning statement include a warning to disclose everything that might be pertinent?
Well, the thing is that, and this is where it differs in Holland, if I've been involved in a shooting incident, I don't get treated like a suspect off the bat. Of course, there's a judicial process that follows. But you're a police officer. You've sworn an oath, and I take that seriously. So I come with everything I can say about that incident and the circumstances, and that is normal. And I think that path could have yielded different results. But the prompt bringing of IPID to that scene, which is a requirement, and IPID not having the resources to adequately manage that incident, really? That makes it really difficult, because now you create a reality where you've done what you're supposed to do, and you've given it to an organization that sends 2 people there to initially administer the incident on site. That is inadequate, and it is unacceptable, because then it would have been much better to actually realize that would likely produce, and I don't know if SABC was in a position to judge what the resources were that IPID could make available, but you'd almost prefer a reality where SABC indeed would have been left with its organizational responsibility to provide the information, because then there wouldn't have been warning statements, but there would have been witnesses of truth that are obliged to speak the truth. And you would have at least, I think, in terms of information, have had a far larger bulk than you have now.
Mr. de Rover, when you answered the interrogatories that are quadruple U 2.6 from Curls, you answered those on the 26th of August of this year. You recorded that you had not read all of the statements of the shotists of the 16th of August. Is that still the case?
Well, it's still the case, because they all sing much of a tune, and they don't offer you much clue. And where they do offer a clue, I'd actually want detail, the same detail that you want. So they are a frustrating bunch of statements in that sense, and that is a given.
And that's putting it mildly. Mr. de Rover, in your first statement, Triple F11, page 18 of that statement, paragraph 77, there you set out what we could call a statistical analysis of shooting at Marikana. And we understand, because we've engaged with you on this, we understand the limited purpose for which you've cited all of the statistical evidence that appears in your statements around US shootings and the like. But I would just like to clarify you that you'll accept that the analysis you've presented to the Commission works on averages, and it doesn't present the actual data of shots fired by individuals. It's averaging out.
This morning I said I took a different tack to the other experts because I sought to act in complementarity. Now, I can only reiterate your concern that I wasn't seeking to justify the shootings, and I'm still not. What this methodology does is give you a footing for a quick scan of any shooting incident. And the reason why this morning I said I have the Special Rapporteur's report when Professor Philip Alston was Special Rapporteur and he did a country study on Brazil. I've worked for him in the sense that I advised him, but that's roles without acknowledgement or glory. But you try and assist the Special Rapporteur if you can. And he's used those approaches to make quick analysis, am I looking at something dirty or not? And the second thing that I think is an important lesson to take is there is, I think, an overestimation of what you think the police can do. And especially when it comes to use of firearms, there is, I think, the biggest lesson to draw from those figures and from the narrative that runs around it is that if an officer is on his own and he's supposed to fire shots under threat, on average it's about 50% of those rounds that will find their target. Now, that's not meant to explain shootings. What it's actually meant for is to improve training. And SABC trains police officials on a range with a static target at a set distance where your breathing is normal and where you get, in your own time, the chance to fire at that target. And surely if you can hit it at 15 meters, you can hit it at 3. That is the base contention, and it's erroneous. Because if you put officers under stress, even just by simply asking them to sprint, jump, lift, carry, and you make them tired, and you give them then, still, it's a static target, and now they're tired, and they have to shoot. Their results drop dramatically. If you take 100% of the first score, then in the second similar test, they only score about 30%. Now make it more difficult. Now it's a moving target. And the target is shooting back at you, or at least you think the target is moving back at you. The chances that you actually hit it diminish dramatically because those scenarios are currently in SABC not trained, or actually not many police forces train it. When I worked in Holland, we did train it because we realized and were aware of the figures that when police officers get confronted by an armed criminal, most of them die, 75% in the US die at a distance from 0 to 7 yards. And that's where they score the worst results when they are forced to shoot. And that doesn't make sense because that offers you a problem that you could solve through training. So all I've tried to do with offsetting the results is to say, I know that the number of shots fired is horribly high. But I can show you, and there's more recent examples that have come out of the US from Philadelphia, where 4 police officers fired 138 rounds into a car. The mind boggles how that happens and why that happens and how that can ever be justifiable. But I just try to offer it as a basis to say, please don't be distracted by the number at the onset. Let that not cloud your focus on what you actually need to focus on, which is the justification.
But Mr. de Rover, we would contend that using averages, and for example you say on average it was 6.18 rounds per officer, that in fact clouds the inquiry that this commission needs to make, because it needs to inquire for each and every officer if they can justify each and every round. And of course we know, for example, we have Constable Kumo who fired 17 rounds, Constable Klongwane fired 15, Constable Molotoa guy fired 24. So your exercise will not assist the commission in trying to establish if it has sufficient evidence before it for each officer to justify each round, will it?
Look, with humbleness, as an expert, I would never be able to detail that information for you. The only ones that can are the officers concerned. And
right.
I acknowledge that averages hide the peaks, but they give you a base idea of the problem. And I think one of the problems is that there is a problem with the accuracy of shooting, and there might be a recommendation required that, how do you say, SABC could usefully provide information on how officers are taught to shoot. How frequently are they subjected to training? How often are they actually given the chance to practice those skills, and not under clinical circumstances, but under more realistic circumstances that would match possible threats they face. And I totally, look, I know the rules that you quote, and I fully agree with that you fire one shot, that doesn't automatically justify numbers 15 and 16. You would still, at every pull of the trigger, need to prove the existence of an imminent threat to life or serious injury. But only the person pulling that trigger can tell you that.
Unless his firearm was an automatic.
Well,
Yes, Chair, I'll
there
get
is
there.
there is proof of that, and
I take it you don't approve of that.
no, but you know what it shows is what in jargon is called a thumbing mistake. The catch on the R5 pushes from safe past full automatic to single shot. Now, you make a mistake, you're stressed or whatever, or you don't check, you don't push that far enough, it's on automatic. And people have admitted to me that they fired inadvertently on automatic and that a burst went off that might well account for 5-6 rounds on one pull of the trigger. So that is another reality that you must contend with. Whether that is ineptitude or stress, I can't answer, but I know that individuals have admitted to it.
But whatever the explanation, whether it was inadvertent or not, you would accept that that is reckless.
I've said yesterday that I think that R5 rifles do not belong in public order management. And if you take away the possibility for them to be used, you can't have the reality that you need to deal with the consequences. And in a blanket answer, automatic rifle fire doesn't have a place in law enforcement. I'm sorry.
Mr. de Rover, you described a moment ago the SAP's firearm training as static target at a distance, standing still, unstressed. Are you aware of whether the SAP's firearm training, in addition to testing accuracy, ability to hit a target, whether it also tests judgment, distinguishing between a threat and a non-threat? Does it have any judgment component to it that you're aware of?
I think there is a theory component that police officers go through, where obviously that aspect of judgment is taught to them or told them, you know, that acting in proportionality means nothing if you can't act proportionately when the situation occasions. So the problem is with operationalization. What I see concerns, because I don't think that SAPS training in elements is an adequate reflection of the threats and the real circumstances policing every day here puts on police officials. So I think they're poorly prepared. I think that my preference would be that judgment is part of active shooting training, so that you create shoot, don't shoot scenarios. And there's very sophisticated ones that have a video wall that even interacts with your voice commands. So you have a suspect with a knife, and you draw your weapon and you shout at the suspect to drop the knife. The program actually reacts to that, and the suspect will drop the knife. And those moments allow an instructor to judge student response to more realistic scenarios. And I think if you separate shooting from classroom, that connection isn't necessarily made. Like I can put 20 people in a room here that will recite for you the definition on proportionality in the use of force, but if I put them in a scenario where they have to use it, I'm not so sure that I could say with as much confidence that they all will behave in proportion to what confronts them, because that is a function of what they are capable of physically and how strong they are mentally and how they judge the requirement of that particular situation, and it becomes very much individual.
Mr. Trevor, the removing of one's finger from the trigger when you're firing, especially in automatic, is a conscious decision. There's some writing about that, isn't there?
That's why I was saying in answer to your question yesterday, why don't people go for their 9mm weapon once they hold that? it becomes fixation. The basic training in firearms use is finger is off the trigger. That's a safety thing. The other thing is, if you have a pistol in one hand, you go to grab something with your other. There's double-handed reflex. So if you have your finger on the trigger, and there's recorded incidents of this, that I have my pistol, I have my finger on the trigger, and I grab this bottle, I might actually inadvertently pull the trigger with my other hand. And that obviously gets worse if I'm at that time grabbing a suspect that I want to control, and I'm having my pistol and a finger on the trigger. So base doctrine in training is finger off. It's along the trigger guard. Base doctrine is that your weapon is on safe, and that when you need to fire, you bring it to single shot mode. A pistol doesn't know automatic, so it's either safe or it is on single shot. An automatic rifle will have the choice to select from either full auto or single shot. Now, if you take the German-made Heckler & Koch, which fires 9mm rounds, and which is designed for use in law enforcement, there the selector switch goes from safe, single shot, three-round burst to full automatic. So it's virtually impossible, unless you do it deliberately, to select full automatic. But the R5, it's inverse, and it shows that it's designed for warfare. So it's safe, or it's initially on full auto, and if you go one further, it's on single shot. So you have to pay attention to what mode you select. But if you are under stress, or you fear that your life is at risk, mistakes are being made, and it's the possibility for it is there, then it's only a matter of time before it occurs. And the only thing standing between you and that is frequent training and exposure to scenarios that try to simulate that stress and force people to confront it. But if you never do, and then it happens, that mistake gets made, because in potential it was always there.
Mr. de Rover, in paragraph 77 of your first statement, FFF11, the final sentence there, you're dealing with scene 1, it says, I do see evidence in this scene for what is called associative threat perception, i.e. officers firing because others were, without necessarily having perceived that threat themselves. My first question on associative threat perception is, do you limit it to what you see for scene 1, or do you also think there was some evidence of what you call associative threat perception in scene 2, based on the interactions you've had with members at scene 2? Do you limit it to scene 1?
I see it particularly at scene 1, and I think if you take some of the stills, or if you would freeze frame on some of the images of yesterday, it's worth have a look at that, and you can see that some people are responding because others are, but I don't necessarily think because they saw a threat themselves, and it's probably also why you get that cascade that mounts like a bell curve and then comes back down. And it's a serious worry, because this has to do with experience and exposure to this type of incident and scenario. And the problem is that now we're talking very dangerous scenarios. How can you train them? And actually, I'd like a reality where you don't need to train those.
But Mr. Drover, my question was, do you have a view that there is associative threat perception operating at scene 2 as well?
There is, I think there is, especially...
And why do you say that? Well,
speaking to people on the southern side that were brought there by General Naidu, some of the K9 members, I asked them, what were you shooting at? And why? And 2 of them talk about an individual darting in and out with a handgun. And we found on the day, but it's useless, because on the day where one of those officers was lying, and there was no cover where he had to go down, because he said shots were fired at me, I had to fall down in the grass. And there's a rock in front of him, and it has a strike mark on it. That was confirmed is a bullet strike mark, but that's in March 2013. I can't say when that strike mark happened. But it sort of then, on face value, it supports his contention. And the ballistics experts that were there admitted they missed that one. They didn't see it because their efforts were very much focused on recording the shots that had gone in, but not necessarily on identifying the shots that had gone out. And the same happened on the western side, where Captain Kidd is. There's a rock that shows at least 6 strike marks of bullets that were never recorded. Problem is now, I can't say they were made on the 16th of August.
Can you say which direction they came from?
Sorry?
Can you say which direction those strike marks
They
came from?
would have come from within the copy, because that for where they are placed, they can't have been placed by shots from the police.
I'm going to take the tea adjournment in a minute when it's convenient for you to do so. But can I ask you, in relation to associative threat perception, is there literature on it? I don't expect you to tell us now, but can you perhaps give us a list of books or articles that deal with that, those that you find particularly helpful?
Chair, in response to our interrogatories, Mr. de Rover provided the HRC with an article that describes the phenomenon in U.S. shootings. We can provide that.
That was just to illustrate, because you have had for 1.5 years at the evidence leaders, there are 3 binders that actually contain far more. I just used it to say, look, here's just one example of what's contained in those folders. It's not the only one. There's a raft of articles that I put in there. The problem is that I had to select.
If these articles are with the evidence leaders, and we can look at them after, we'll get them from them. Can we take the adjournment now, or do you want to round off?
Chair, if I could just round off associative threat perception. Mr. de Rover, so given your definition of it, that it's essentially firing because others are firing, even if you don't perceive a particular threat, you would agree with me that that doesn't provide a lawful basis or any justification for that use of live force, correct?
But that is essentially the problem, that it exists, and I think there is, the hard thing is, you ask a scientist, you say, no, it doesn't exist, because you can't prove it. You'd have to think of a way that you can establish a simulation where you could prove that element to be true. But it is a recurring theme in a lot of articles that talk about multiple officers using their firearms and the reasons for which they used it. And just taking that example of the canine on that side, there is that claim of a person darting in and out and shouts being made to others. And the problem is that the rules of international law simply talk about a requirement of an imminent threat to life or serious injury. It doesn't say that if you feel that your colleague is firing at something that poses a threat, you just take fire in that same general direction, and you take by proxy the threat to life to also apply.
A voluntary act.
Sorry?
Is it a voluntary act? I can understand if my colleague is firing, and if the fact he's firing makes me involuntarily fire, then you wouldn't have a conscious act.
Well, it's more like panic spreads in a crowd. If someone starts to yell fire here now, others might, when we see smoke, might take that up, and all of us start to scramble for the door. And it's been compared to that, that there is a panic reaction, if you will, that all of a sudden now a police officer is firing. There must be a reason for that, a rationale, and others, without having properly appreciated what that is, do the same thing. I think it's much more readily visible in armed combat. There is much more footage available of it too, where you can see a patrol, one soldier perceives a threat. He's not going to say, guys, there's a threat on that side. He opens up fire, and the immediate response of the others is to do in the general direction the same thing until they actually ascertain what it is they are shooting at. And I see that replicated in law enforcement in instances.
Yes, I see. Mr. Roux, is it convenient?
Yes, Chair.
Take the tea, 15 minutes.